Good afternoon, everyone. I see a few people coming in at the end. There's a lot of seats up here in the front. If you can come on down. You can always tell the people who are coming from far away get here first. The people who live in the building come sliding in under the line. Thank you all very much for being with us today for Constitution Day. I'm Joyce McConnell. I am the Dean of West Virginia University College of Law, and I'm delighted to welcome you here this morning to hear our Constitution Day lecture, which will be delivered by the very distinguished Professor Ruth Ann Robson, who is visiting with us this year as the John T. Copenhaver Endowed Chair. Professor Valerie Vitek is actually going to introduce Professor Robson, but I am actually going to take a minute to introduce Constitution Day, because it's not something that we think of every day of the year, although we probably should. I refer to Constitution Day as Senator Byrd's legacy. Senator Byrd loved the Constitution, and when he came here, every time he appeared, he had his Constitution tucked in his pocket over his heart, and he would stand up here and he would take it out of his pocket and he would wave it wildly. We loved that about Senator Byrd. On July 2nd, 2010, America watched Senator Robert C. Byrd's memorial service held on the steps of the West Virginia Capitol. To West Virginians, he was our senator. To many Americans, he was the nation's constitutional conscience, known for his ever-present pocket constitution. In his 60 years plus in the Senate, he did much for the state, the Appalachian region, the nation, and the world. Yet, in the midst of his good works, one accomplishment often goes unrecognized, and that is that he is the author or the establisher of Constitution Day. In 2004, at Senator Byrd's behest, Congress designated September 17th as Constitution Day, the day when the founders of our country signed the Constitution into law. Congress specified Constitution Day as a day to commemorate the formation and signing on September 17, 1787, of the Constitution, and to recognize all who, by coming of age or by naturalization, have become citizens. No document mattered more to Senator Byrd than the Constitution. Motivated by the knowledge that many Americans know little about its significance, Senator Byrd saw Constitution Day as a means of educating the public, particularly young people, about the history of the United States and the significance of the Constitution in our formation and our ability to remain a country. In an interview for Scholastic magazine, he's quoted as saying, "There are several founding documents, like the Declaration of Independence, but the Constitution of the United States is the single most important founding document that we have. It's the oldest Constitution in the world, and it is a Constitution that sets forth the structure of government and the rights of the American people. It protects our liberties, our freedom of speech, our religion." Just by reading his interview for Scholastic, which is distributed, as you know, K through 12, we can feel his passion for the document's power. His passion was evident when I first met him at a visit at the College of Law to celebrate the Constitution. He brought with him that day several boxes of pocket-sized versions of the Constitution to distribute to audience members. Some constitutions were left over. We boxed them up and we put them on a shelf in the storage room. Several years later, my daughter's fifth grade teacher invited me to speak to the students about the Constitution. I handed out the pocket-sized constitutions to the students, and they were thrilled. But I didn't know how thrilled until many years later when a university undergrad yelled up to me from the basketball courts at the rec center, "Are you Mrs. McConnell? You don't remember me, but I was one of the students to whom you gave the Constitution. I still have it. Just thought you should know it made a difference for me. And today, I know that we carry forth Senator Byrd's legacy in making a difference for us all and taking this day to remember the grandeur of the Constitution and the rights and freedoms that it has allowed us. Thank you very much, and I now welcome to the podium Valerie Vitek.
Welcome. As Associate Dean for Faculty Research and Development, I've had the honor of introducing many speakers over the past year or so. But in this case, I'm particularly humbled, actually, by my role here today, which is to introduce to you a truly outstanding scholar and person, Professor Ruth Ann Robson, who is visiting with us this year as the John T. Copenhaver Visiting Chair. We are truly lucky to have her with us this year. As you may know, she serves as a university distinguished professor of law at the CUNY School of Law, where she teaches in the areas of constitutional law, family law, feminist legal theory, and sexuality and the law. She's also the advisor there to the New York City Law Review. Being named a university professor, as you probably know, is one of the highest honors that a university can bestow on a faculty member, and it is rarely done. CUNY has chosen to award Professor Robson this distinction as a fitting tribute to her outstanding scholarship and work which has been widely proclaimed as at the forefront of lesbian legal theory and law and sexuality. Professor Robson received her JD from Stetson University College of Law and her LLM from the University of California at Berkeley. She clerked for a federal district court judge and then continued to clerk for a judge on the 11th Circuit Court of Appeals. She practiced law with Florida Legal Services before she entered the Legal Academy. Professor Robson is the author of numerous works developing a lesbian legal theory, which include the books Sappho Goes to Law School, numerous book chapters, and many articles in prestigious law journals, including the New York Law School Journal of Human Rights, Hastings Law Review, Albany Law Review, the Women's Rights Legal Reporter, Australian Feminist Law Journal, and Yearbook of New Zealand Jurisprudence. She's also been published in leading feminist academic journals such as Signs and Women's Studies Quarterly. In an extraordinary tribute to her outstanding work and contribution to the field, CUNY Law School honored Professor Robson in 2005 with a special symposium devoted to her work and highlighting the impact it has had on the Legal Academy and American society. And in fact, Dean McConnell and Professor Jim Elkins participated in that symposium, which was published in the New York City Law Review, Volume 8, Issue 2. Professor Robson has given many presentations on women and sexuality in law in the U.S., Australia, and in New Zealand. I've actually had the pleasure of participating with her in a conference in South Africa on comparative constitutionalisms. She's also served as the Bram Fisher Research Chair in South Africa at Wits Law School. She's served as a collaborative research fellow at the University of Sydney in Australia and has visited other institutions, law schools in Canada and around the globe. And what I find actually most humbling, in addition to having established herself as a leading feminist and lesbian law scholar, is that Professor Robson also excels in creative writing, which completely humbles and shames me. In addition to her prolific legal scholarship, she's a frequent contributor to Out magazine and has been awarded many prizes for her creative work, which includes at least 4 published novels, perhaps more, short story collections, poetry works, and creative nonfiction. And in fact, as one example of such awards, she was appointed to be a fellow in nonfiction literature by the New York Foundation for the Arts. So, with all of that said, I am extremely pleased to welcome Professor Robson to us, and we look forward to hearing her thoughts today.
did you take my?
No, but I think.
It's like I'm being humble. I don't have any notes. Well, thank you very much for having me, and thank you for allowing me to visit this year, and thanks to the Copenhagen Chair and the Mayor Fund. And thank you for letting me give this Constitution Day talk. I wanted to talk about same-sex marriage, believe it or not, today. Well, obviously you believe it because that's what it's on the program. And one reason I was interested in it was trying to look at how the constitutional values kind of refract through same-sex marriage and how same-sex marriage refracts back on the Constitution. And so looking at those values and looking at the doctrine to some extent and also the larger theoretical issues and thinking about them. Now, the major theoretical issue that we start to think of immediately is equality. And we're going to be talking, or I'm going to be talking some about equality, but I'm also going to be talking about some other issues. Now, obviously, we, as Dean McConnell said, we talk about September 17th as Constitution Day, and that was the signing of the Constitution, and here we have a nice little painting. And one thing that happens, though, in the Constitution, and why I'm always a little worried when we start talking about the framers and the founders of the Constitution, is to some degree they neglected, and there are lots of historical reasons or explanations of why this isn't quite just neglect, they kind of neglected to put in an equality provision. And so they really thought about or didn't think about as much the Declaration of Independence, which of course has its own problems in terms of being about men, but even that they departed from. And it really isn't until we get to the 14th Amendment and the Reconstruction amendments where we start to talk about and actually constitutionalize our notion of equality. And we do that through the equal protection of the laws provision. The other thing that's kind of interesting, however, about the 14th Amendment, and I'm sure many people know, is that it's also really the first time that the Constitution becomes a gender document, right? So that the second part talks about male citizens, right, and male inhabitants. And before then, and I don't know that people talked about it in this way, but before then you could probably pretend that the Constitution was kind of a gender-neutral document. Obviously, the 14th Amendment, Section 2, you can't do that anymore. And this notion isn't really fixed until we get the 19th Amendment. And we also have some sort of trying to fix the way the 14th Amendment also put Native Americans kind of outside the body politic as well. And we have the Indian Citizenship Act as well as the 24th Amendment, which we generally think of as about poll taxes, but it also really breaks the connection between taxing and voting, and it does that for Native Americans as well. Now, the 19th Amendment kind of seems as if it's not really a big issue, but one of the things I do sort of in my spare time is the Constitutional Law Professor's blog, and you're always like looking for, you know, anniversaries or something to come up because there's not an important case every day. And I put up the 19th Amendment, had a nice little picture, I thought, and actually a lot of the comments were negative. A lot of the comments were, that's what's wrong with this country, allowing women to become or to have the vote has made the state into a nanny state. And I was sort of like, wow. I thought this was kind of not controversial, you know. But anyway, so there are a few constitutional provisions in addition to equality that I want to talk about today. And I'm going to be focusing on Proposition 8, but I'm also going to be doing some history. So in thinking about what's out there in terms of what we think about equality. We think about substantive due process in terms of same-sex marriage. Problematic, right? It's about process, but where's the substance? Because the word substance isn't in the Constitution. And really that's where the court has found rights of privacy, rights of bodily autonomy, rights to family life. And we don't have an explicit provision in the Constitution. Federalism and the 10th Amendment, not so obvious, but really has become a very heated and very important discussion in same-sex marriage cases. Who has the right? Is it a state right or is it a federal right? And interestingly, we're seeing some states' rights kinds of arguments that I'm going to talk about in a little bit around the 10th Amendment, where states have sought to protect their version of same-sex marriage. Separation of powers really is a huge issue in this area. The most obvious one is about the role of the judiciary. The role of, can courts decide this? And we see that both in the federal system, where we're talking about, quote, unelected judges, but we also see it in the state system. And should courts be deciding these matters, or should it be left to the legislature? And another problem is the role of the executive, which is going to come up in the Proposition 8 discussion. What role does the president have? What role does a governor have in defending laws, even if the governor or the president doesn't happen to agree with these laws, or even if the president or the governor thinks that these laws are, quote, unconstitutional? And in the Proposition 8 case, these things have really come up. So I want to do a little background before I get into Proposition 8 and talk about some of the state cases as well. And so here's kind of a timeline of same-sex marriage cases, litigation and statutes. And I'm going to be coming back to this a few times. But I wanted to start a little bit with the 1970s, because one thing that happens is we tend to think of same-sex marriage litigation as just happening now. But there were a few cases in the 1970s. And these cases are extremely interesting. They come out of gay liberation, as it was called then, and women's liberation, as it was called then. And they were used, both the idea of them and the cases themselves, were used in another amendment that did not become an amendment to the Constitution, and that was the ERA. And so the ERA would have been a constitutional amendment in terms of sex. And Phyllis Schlafly, who some people might remember, said things like, if you just look at the amendment, what does the word sex mean to you? Well, it means homosexual, bisexual, heterosexual, sex with children, or whatever. And one thing that you can be sure of, she would say, is that if the ERA is passed, there will be homosexual marriage tomorrow. So homosexual marriage was kind of a wedge issue, although people didn't talk about it then. That and, of course, the ever-present threat of same-sex bathrooms. The litigation at that time, there are a couple cases, but one case that's especially interesting does take place in a state that adopts an ERA as a matter of its state constitution. And people litigated and said, yes, this gives us the right then to same-sex marriage. And the courts were completely dismissive of that and basically said, no, that's not what people were voting on when they voted on the ERA. And there are a few other cases, and generally those cases came down to, no, there can't be same-sex marriage, and we have two sources for this. One is the dictionary, and the other is the Bible. And so, as you can see again from the timeline, nothing much happens for about 20 years. People are doing other kinds of activism, and we have the AIDS pandemic. A lot of other things are happening, and in terms of what's happening in terms of relationship recognition, it's mostly about domestic partnership, things like that. In Hawaii, however, in the 90s, people bring suit, and they bring suit under the state constitution, and the Hawaii state constitution has both a privacy clause and an equal rights amendment to its state constitution. The Hawaii Supreme Court decides that privacy has nothing to do with it, but that the ERA, the Equal Rights Amendment, on the basis of sex does have something to do with it. And one thing that's interesting about the Hawaii Supreme Court opinion is footnote 11, believe it or not. Many things happen in the footnotes. And it says that this has nothing whatsoever to do with sexual orientation. This is just about sex, because that's what it says on the face of the statute, male and female. They find it subject to strict scrutiny. They send it back for a full trial. And as the trial is going on, people are getting very worried. People are worried about what this will mean for other states. People are worried as well what it will mean in Hawaii. And the Hawaii legislature does this very interesting thing, and they put a referendum to the voters. And we're going to see a lot more of that. But the Hawaii legislation and referendum is actually the most interesting because it doesn't say marriage will only be between a man and a woman, which is what the more recent ones will say. It says only the legislature can decide whether marriage is between a man and a woman or not. So of those cases, the other one that I want to spend a little bit of time on is the Iowa case, because it's kind of back in the news and because it's really probably the best case of all of these, just in terms of its analysis, just in terms of its rhetoric, and not necessarily the result. So the Iowa Supreme Court, their first footnote cites the state motto, which is on their flag. And they say, this is our motto, our liberties we prize, and our rights we will maintain, and we're going to stick to it. And then they say, you know what? Iowa has a unique history. Now, in Vermont's case, Vermont had sort of talked about that as well. And people thought of Vermont as having a unique kind of pre-colonial history. But I, for one, actually had never really thought of Iowa in those terms. But they make a really convincing case. And they talk about our first case we ever decided as a state was an anti-slavery case. We gave women the right to vote. We allowed women to be attorneys. And they kind of go on and on and on in this vein. And it's a unanimous opinion. And then when they get to the actual discussion of it, they say our Constitution has some equality provisions, and they're like and unlike the federal Constitution, but that's really not going to make so much difference to them. They're going to go for an equality analysis. And the equality analysis that they do is, it's not that it's kind of brilliant, it's really an A exam. And I have to say, I had so many students when this opinion came out, after they read, they said, it seems like a constitutional law exam. And my reply was like, no, actually a constitutional law exam should seem like a good opinion, and here is one. And so they talk about it as a sexual orientation classification. They find it intermediate scrutiny, which is the same as gender, applying the factors that many of us know kind of as the Caroline factors. They talk about immutability. In other words, whether it has to be something that is unchanging, and they say that's not really so important to them. They talk about political power. And then they go to what are the state interests. And here really is, in these cases, where a lot of the litigation and more interesting arguments are. And the state put forward 3 interests, and these are somewhat common. Support for the traditional institution of marriage, which the court rejects. The court says it's no business of the state to support tradition or not. And then they kind of go back to slavery, go back to women not being attorneys, and sort of what their notions were. And the tradition isn't always a good thing. They accept that the state has an interest in children and accept that the state has an interest in finances, but find that those really aren't served in the correct way, tight enough in terms of the analysis. Again, it's a unanimous opinion, 2009, and either because of what Iowa's political structure is under their state constitution, whether it's because who's in political power, not really much is made of this. Things are just going along. But Iowa also has merit retention. So merit retention of judges means that voters vote on, yes, no, should this judge be maintained. And I'm not going to show all the ads, but here's kind of a idea, or just, of one that you can already tell. that there's been a concerted effort by some anti-same-sex marriage groups to go after the 3 judges who are up for merit retention and call them activist, ultra-liberal, vote no. These are not people that you want not having Iowa values. And the interesting thing about the Iowa values that kind of comes up in the ad is you see pictures of people hunting, people working with their children, which then I came to see was homeschooling. So those kinds of things that the activist court could overturn. So that's kind of what is happening there. And those merit retention, and I think that they're really of interest in terms of constitutional structures, especially in terms of state constitutions, really have had a lot of controversy over the years. So here's 2 pictures. Probably most people know Justice O'Connor. She's really made it part of her retirement project to talk about state court judges and their retention and how they need to be insulated from politics, and talking about whether elections are a good thing or not, and she's really coming down on the side of not elections. The other picture, anybody know? Rose Bird, who was the first woman on the California Supreme Court, appointed by Jerry Brown, who we're going to hear a little bit more from in a little bit. And she was subject to non-merit retention. Groups went after her on the basis of the death penalty. And at one point, the death penalty, and I used to do some death penalty litigation, so it seems like I'm always doing litigation that somehow is controversial, I don't know. But really went after her, and she was not voted to retain. And in Florida, people went after 2 judges as well, Leander Shaw, who was the first African American on the Florida Supreme Court, and Rosemary Barquette, who was the first woman on the Florida Supreme Court, who's now on the 11th Circuit, and they actually won their elections. But one thing that happens in terms of First Amendment that's quite interesting is that in the election, the judges, because they have judicial canons of ethics, can sort of fight back and sort of not fight back. And so they need other people to fight for them, and then other groups are saying this. So you're seeing all these ads on television, and you're not even quite sure exactly what they're about. But you can be sure is that the judges who are being fought not to be retained are being labeled as activists. So going back to the timeline, and so not to get confused, the other one that I wanted to just mention a little bit is Goodrich, and that's the Massachusetts case. And that case, the court, by divided opinion, holds that same-sex marriage must be allowed under the Due Process Clause and the Equal Protection Clause of the Massachusetts State Constitution. The court's opinion kind of puts them together and says, there's some difference, but not all that much difference. And as a kind of analytic structure, I think it's not always the best. But people generally don't look at the analytic structure. They're generally looking at the outcome. And the Goodrich opinion, which was decided close to the end of the year, really became a feature of several State of the Union addresses. So here is George Bush talking in 2004, right after the opinion. The opinion was at the end of 2003. He mentions it again in 2005, mentions it again in 2006. And the amendment that he's talking about is a constitutional amendment that's being proposed that's called the Marriage Amendment. And that amendment would be amendment to the United States Constitution that defines marriage for federal and state purposes as only being allowed as between a man and a woman. And that amendment gets some traction but doesn't really go too far. What has gotten traction and what was already as part of the law by this time is the Defense of Marriage Act. And that was decided, or that was promulgated by Congress and signed into law by Bill Clinton. There are 2 sections to that. The first section just really has the title. And so there's Section 2 and 3. Section 2 is about what states can recognize amongst each other. Many people say this really doesn't do anything other than say Congress believes in the full faith and credit clause. There's an argument that maybe it does some other things, but generally it's about, does a state have to recognize a same-sex marriage from another state? And most people were already saying the answer is a big, profound maybe, right? And public policy exceptions, all those sorts of things. And so that section is really not all that controversial. The other section, Section 3, which we call the second section, even though it's Section 3, okay, really does change the law. And what it says is that the federal government isn't going to recognize a marriage that might be valid in the state if it's a same-sex marriage. The general rule has been that the federal government recognizes marriages in the states. There are some exceptions. I think the big exception is immigration, when the immigration courts look at, quote, immigration fraud, fraudulent marriages. There are a few other exceptions. There are some things in which the Social Security Act tries to protect innocent spouses who are, married to two people, things like that. But generally, okay, this does change the law. And what happens in Massachusetts is that Massachusetts kind of goes along for a few years. They're having same-sex marriage. People are saying you've got it because of activist judges. The state really isn't so worried about it. The state is kind of making money off of it. But there are some problems, and the problem that I always think of is just filling out your taxes, right? So you're filling out your taxes, you're married in the state, you're not married for the federal government, those sorts of things. So 2 lawsuits are filed against Section 3 DOMA. The more interesting, at least from a constitutional perspective, is the lawsuit filed by the state of Massachusetts. So Massachusetts files, and their problem is that they are having some financial difficulties because of the federal government not recognizing same-sex marriage. So they have a claim about VA benefits, and their claim is about the VA administration, the federal VA administration says that it's going to come after them for millions of dollars because of who they've buried under VA benefits when they shouldn't have been entitled to it, meaning same-sex partners. And the other one, which I think is a little bit more obvious, is the Medicare and Medicaid, right? So they're not getting reimbursements from the federal government, and they're having to pay taxes. They sue, they litigate this, and the trial judge, federal district judge, agrees and basically says, and I've even left the citations up there for cases that some of you might recognize, you know what? Family law and marriage has always been a province of the state, and you, United States Supreme Court, keep telling us this, and here are the citations, and this is inconsistent or undermines the 10th Amendment, and therefore the state should always have the complete right to determine the contours of marriage or the qualifications for marriage, and this section of the Defense of Marriage Act is unconstitutional. The companion case looks at it from equality, and this is filed by some same-sex couples. It's interesting for really one big reason, and that is the government interest when DOMA was passed. So the government interest that will kind of recognize tradition, children, resources. The Obama administration, in defending this, says, we're not going with those. The trial judge, the federal district trial judge, says, you said you're not going with them, you're not relying on them, but we're going to go through them anyway, I, the trial judge. And he goes through them and then says, I don't find any of them valid or sufficiently related. Okay. The Obama administration in litigation says, we are now relying on this government interest. Our government interest is preserving the status quo, that things shouldn't change while the states figure this out. And that's kind of an interesting notion. The trial judge, however, rejects that and says, actually, Defense of Marriage Act changed things. The status quo was the federal government relied upon the state definition, and the Defense of Marriage Act actually changed that. So the issue sort of now, and not legal issue, is what the Obama administration is going to do in terms of an argument and whether or not they're going to appeal. They have until October 11th to appeal. There's kind of a movement, and people signed petitions to try and argue that they shouldn't appeal. And so kind of bracket that in thinking about what might happen if the federal government doesn't defend a law that it itself has passed. And that's where we get to Proposition 8, which is the last thing I'm going to talk about. So Proposition 8 is something that we've all kind of heard about. Right? And I want to back it up a little bit and talk about not just how it came about, but some of the other issues involved in California. What was happening in California was the absolute antithesis of any kind of status quo, right? Everything was all over the board. There was domestic partnership law, and then the legislature passed a bill and said marriage is a civil contract, meaning same-sex marriage was okay. They did that while it was winding its way through the courts, the California state courts. Schwarzenegger vetoed the bill on the basis that this was for the courts to decide and not the legislature. And you have to remember, this is really at the same time that George Bush is saying, no, the courts are out of control. And I have this kind of fantasy of a phone call between the two of them trying to talk about no, it's the courts that are out of control. No, it's the legislature that's out of control. This is our program. So there's some disagreement about that. It's winding its way through the courts anyway, well, after he vetoes it, and the court gets to the California Supreme Court, and it's called in remarriage cases, which is really a wonderful name because there was about 3 or 4 different cases. Court hears oral argument, decides in May of 2008 that a same-sex marriage exclusion violates the state constitution, and they also find that it's a sexual orientation classification. They go through they have their own sort of Caroline products notion, which is how you determine whether something's a suspect class or not. There's something as a matter of state law. And they hold that sexual orientation should get the highest level of scrutiny, and it's going to fail that. Okay. November 4th, 2008, Proposition 8 goes on the ballot. And as we know, it's going to pass. So a couple things happen about Proposition 8 that I want to talk about. So it goes on the ballot, and it does pass. And one thing that happens is that there was tons of money coming into the state around this, from people who lived in the state and people who didn't live in the state. So there were some people, and these people I think you could correctly call kind of activists, who got the lists of donations, which are public records, and they had some problems getting them, and then kind of did some activist technology and put them on Google Maps. So this is Orange County, which, as anyone who knows California pretty well knows, that's probably the most conservative place in California. And so it's no surprise that there were lots of, little things. Now, the interesting part was that you could click on one of those things, and now I'm going to go to Berkeley, okay? And you could click on one, and I was actually looking for my landlord, who I didn't find, or my previous landlord. And you could click on them, you could get the name, what they did, and you sort of had the address, right, and how much they contributed, and the date that they contributed it, right? And the notion was that you would, as an activist, kind of knock on your neighbor's door and say, that money that you gave to the Proposition 8 people, I would like to talk to you about that. Right? So that was deemed sort of problematic. And this issue, and you have to just give me a little leeway here, this sort of issue maybe, possibly, went to the United States Supreme Court and was decided last year. Here's some of the oral argument. Okay. What happened in California what about Proposition 8? And there are a few more examples. And the court seems to be talking about, and seems to be thinking about, they're talking about California, because that was in the news. That was what everyone knew. But actually, they were talking about Washington State, and they were talking about a case somewhat similar, but the issue there was the Washington State Public Records Act, and it was about people who had signed the petition. Okay. The Public Records Act generally meant that if you signed a petition that something should be on a ballot, those petitions were public records, and people could get them. And Washington State gay and lesbian activists got them and were maybe going to do something with them. Maybe if they got the same Google Maps people, they could work on that. People filed a lawsuit to prevent the disclosure of that. And the court said, no, at least as a facial matter, that the Public Records Act is constitutional. I'm going to send it back to as applied and to find out if there's enough harassment here. And in talking about the harassment, the court generally talked about what had happened in California or what had not happened in California. And so there's this real huge slippage there, except for Justice Scalia, who basically said, hey, you're going to sign something, that's yours. This is my favorite part. This is the home of the brave, after all. If you're not brave enough to sign it, basically is his argument, then don't, right? And secrecy is not related to democracy. And he also has this very interesting discussion about secret ballots and how ballots weren't always secret and you should be able to say things and, and all of this. In terms of sending it back for the as-applied challenge, interestingly, Justice Alito says, yes, this is very hostile, and that whenever you have, it doesn't say whenever you have, but since this was about same-sex marriage, this is incredibly problematic, controversial, and therefore there's going to be harassment. And you have Justice Stevens, since retired, who says, a lot of things are controversial, zoning, land reform. If we're going to remove everything that's controversial, we're going to be removing quite a number of things. Proposition 8, to kind of go back to that, passes, as we know. And then there's a challenge. There's a challenge in state court. The name of the case is Strauss v. Horton. It's litigated. Is it constitutional under the state constitution? Different sorts of notions. And one notion is it a revision of the Constitution, in which case it's something broad, in which case it needs 2/3 of the legislature, 2/3 of each house? Or is it a kind of mere amendment? And it's kind of common parlance. I don't necessarily think there's like a huge difference in my language between revision and amendment, but there was one in state constitutional law. The court found, it goes to the California Supreme Court, the court finds that it's a mere amendment. Constitution, Proposition 8 is valid, but it's not going to be retroactive. And as a result, there are 18,000 same-sex couples in California whose marriages are valid, but if you wanted to have the same marriage tomorrow, you couldn't have. So that's kind of where things were. But here we have these, and they're kind of dressed the same because they're part of the Time 100. And we last saw these people kind of together, but not together, in Bush v. Gore. Okay. Olson, representing Bush. He later becomes Solicitor General. And Boies, representing Gore. Olson is also, and this kind of becomes a little bit pertinent, he was also kind of instrumental, perhaps, there's some disagreement about how instrumental, in the Federalist Society. He's a board member of American Spectator. He was deeply involved in efforts to unseat, I think is the best way to say it, Bill Clinton. So he's kind of got, very good conservative credentials. Walks in They get together, found an organization, and they both have lots of money. Boys probably has more money. Found an organization and decide that they are going to sue challenge Proposition 8 based on its constitutionality in federal court. And they do that, and they file the complaint. Not everyone is overjoyed about this, and people are trying to intervene. National Center for Lesbian Rights, ACLU, Lambda Legal Defense Fund, as well as the city of San Francisco. The gay and lesbian and transgendered organizations' argument really is like, well, they have two problems, right? One problem is, point blankly, Olson, right? Like, what are you doing? Are you doing to undermine this? Are you trying to set bad precedent? What's the story here? The other is, even if you are both well-meaning, you are not members of this community. You don't have the factual basis. You don't have the history. We do. Let us intervene. The attorneys and the plaintiffs say no and really strenuously object to the intervention. And they do that also for San Francisco. And the judge denies their intervention. The other problem that's going on is protectmarriage.com, which is sort of sometimes the name actually of the organization, the .com part, that filed the complaint. The answer comes from Jerry Brown, who's now the Attorney General. And Jerry Brown basically says, hey, fine with me. I think it's unconstitutional too, which is kind of what you want a defendant to say. And I've actually had that happen once in my career, and I still remember it. It was a great moment. And Schwarzenegger isn't so explicit, but reading between the lines kind of says that too. And so you've got a lawsuit and no real defendants. And the judge says, okay, I'm going to let Protect Marriage intervene, and they're going to be called, which is always the problem, right? What are we going to call these people? The proponents. And so we have plaintiffs, proponents, and the defendants who are sort of over here. So we can't see him very well, but that's Judge Vaughn Walker. He's the Chief Judge of the Northern District of California. Lots of pretrial motions going on, summary judgment, trial memos, all of this. Really the most contentious thing was the interveners. Until he says, well, there's also this pilot program in the Northern District of California, as well as the entire Ninth Circuit, to transmit, we're not even going to call it televising, but transmit proceedings. And the notion was it would be contemporaneous transmission to courthouses throughout California, and then uploaded, and here comes the YouTube part, to YouTube, where if you were really devoted, you could watch it all night, kind of in opposite time. And everyone seems sort of happy about that, except for the proponents who sue and bring it to the United States Supreme Court on an emergency stay petition. And 5-4, the United States Supreme Court says shouldn't be transmitted. And that's because the correct procedures weren't followed in the Ninth Circuit and by the judge. The dissenters, of which there are Stevens, Ginsburg, Sotomayor, and Breyer, who writes the opinion, says, this isn't about procedure, and what about the procedure for a stay? And for that, you have to show harm and those sorts of things. There were lots of also amicus briefs that you can imagine from news organizations. So the YouTube is off, right? People are, during the trial, tweeting. I never thought I'd spend so much time listening to little tweets. Tweeting, and also taking notes, and then there are transcripts, daily transcripts at night. What happens after the trial, before we get to the opinion, is that we have now on YouTube, you can watch the entire trial as a reenactment. So they have And I always think it's kind of like out of work actors, but they're actually not out of work because they're getting work out of this. And some of them are actually, when you look at it, like actors even I know, which is kind of impressive since I don't follow that too much. And they kind of pick people who sort of look like this. And they have like the characters, and you can watch the entire trial. And the script is the 3,000-page transcript, which they really don't deviate from. And to their credit, they are not mostly reading from. It's kind of an amazing thing, and this is on YouTube. So you could watch the trial while you were waiting for the opinion, but the opinion finally comes down. It's 138 pages. 100 of those pages are about the trial testimony. Okay? And the judge makes credibility determinations, finds that fundamental right of marriage, and applies equal protection, rational basis. Now, part of the problem of the trial and the trial findings is that the proponents really only have 2 witnesses. Now, you can win a trial with less witnesses than the other side, obviously, and many of us have probably done that. But it was probably not the best strategy. One witness was someone who was really talking about democracy and the referendum, and the other witness really talked about the family and parenting and things like that. And so the judge, and this is kind of the final notion that he says, or the not quite the holding, but quite the reasoning, basically says they haven't proved their case, and I can explain that in 100 pages. He has his conclusions of law, but this is it. Okay. He's asked for a stay by the proponents, probably, although this is a little unclear, but probably before the opinion is even rendered. They file for a stay. He grants the stay. Then there's some back and forth about whether he's going to lift the stay, whether he's going to grant the stay, on and on and on. And then goes to the Ninth Circuit. And now you're going to see the entire Ninth Circuit opinion, which is not something that you can do too much, but grants the stay, expedited on their calendar, and also says, and you know what? We need briefing, and their initial brief is due, as it happens tomorrow on Constitution Day, about standing. Now, Judge Walker had identified this as a problem. Do the proponents actually have Article III case and controversy standing? And it seems kind of a bizarre thing, right? How could you have participated in a lawsuit and then not have standing to appeal? On the other hand, the thing that's also very odd about it, as just looking at it, is that the proponents at trial are also always saying what the government interests are. And one question is do you know what the government interests are? You put this before the voters, yes, but it's almost like, a person who proposed the bill as opposed to the legislature as a whole. So that's where that stands. And if you thought you were going to get out of here without a picture of Schwarzenegger, I couldn't resist that, okay? People sue Schwarzenegger and Jerry Brown, that they think they have a better claim against Schwarzenegger, in state court and say, you know what, you better get in there and appeal. This is just a ministerial act. They file a petition for mandamus, and the California and the California courts, and it goes to the Supreme Court eventually, just say, no, denied. You can't really tell them that they have to appeal. You can't tell them that they have to perfect the appeal, even appear, vigorously represent. It's not their problem. So here we have a few things that most people think are going to go to the United States Supreme Court, but we're waiting to see what happens on the defense of marriage case. And we're waiting for the Ninth Circuit to rule in Perry, which is the Schwarzenegger case. Do they have standing? Do they not? And we're waiting to see whether the Obama administration is going to vigorously defend, or how vigorously they're going to defend. And so maybe by Constitution Day next year, we'll know some of those things, but I doubt it will be resolved even by then. And meanwhile, framers of the Constitution has survived lots of things. I guess it will survive same-sex marriage. Thank you. And since I've used which we already discussed, I was going to use my allotted time, and we're going to go to the reception, and I'll just take questions there. Thank you.